It is Friday, the 2nd of December 2022. This is just a short video, a quick video. Just wanted to cover a couple of short points, things that are happening. Looking at partnership visas, parent visitor visas, the RV21 parent retirement visas, and a quick look at sort of what the options are if you are declined your visa or have an issue. We're going to actually do a longer video on that last topic later on at some point. I just want to cover a quick points today though. But firstly, as always, this video is not legal advice. It's just our commenting on immigration here in New Zealand. If you're looking at legal advice, get in contact with us at the addresses in the description down below. And thank you also to those of you who have subscribed to this channel. We have just hit 7,000 subscribers. So please like and share these videos. Try and help us build those numbers and get our message and information out there to your friends and colleagues who this may be of use to. Partners visas. Now, we've covered in the past that this month is when the partnership work visas for workers will come to an end. As a quick recap, at the moment, partners for most workers can get an open work visa, a partnership work visa. INZ is moving away from that process. So from what INZ have stated in the past and recently confirmed as well, this month, December, is when most of those that availability will end. So at some point in December, partners of work visa holders will no longer be able to apply for a partnership work visa. Instead, they'll be eligible for a partnership visitor visa, and if they want to work, they need to apply for their own accredited employer work visa. Now, of course, there are exceptions. Those who are workers on the green list roles or who have at least twice the median salary, they'll be able to support a partner to go onto an open work visa. Now, this will not end those of you who already have a partnership work visa. That work visa will continue through until it ends. Neither will it impact those who have already applied for a partnership work visa before the changes come into effect. Now, that means that those of you who may need a visa coming up, or your visa is due to expire the next year or so, may want to consider applying for a partnership work visa now rather than perhaps getting caught out and not being able to apply for one in the very near future. If that is the case, then please let us know and we can possibly assist you with getting that visa done in time. Next thing was the parent and grandparent visa category. This came into reopen on the 1st of August, and of course many of you were very excited to have that opening, so that bringing your family and your parents through. What wasn't welcomed was that for about the first 7 weeks, from August 1st to September 21st, many of the applications that were applied for in this new system actually sat there unmoving. It's an automated system where it seems the automation stopped. It somehow took Immigration New Zealand until November to notice that the issue was actually in place and the visas were sitting there and waiting to be processed any further. But that was noticed. They have moved relatively quickly to try and get those pushed through. Some of you may have already had a response come through, and you may have noticed that they were granted a general visitor visa rather than the parent visa. That is just to sort of make it faster, get them pushed through faster. There are some of you who are still in that process waiting for the visas to come through. We've got several of our clients, we are working with immigration trying to get those things nudged through, but the issue has been spotted, it is being worked on, and those applications are being prioritized, but there is a lot of them to get through and they are still working through them. But of course, we've got a question as to why the issue happened in the first place. Now, the 2021 residence visas also have been having continued issues, as we've covered in many videos previously. A lot of you will be aware that the system had complications when trying to get medical details from the e-medical system into the new ADEPT, what they call the enhanced immigration system. Now, I did put a request in, and Immigration New Zealand have provided us with an OAA, Official Information Act request, related to these issues of the medicals not coming across. They wouldn't let us know how many applications that they'd asked for medical information on. They said it was too large a number to find out. I question that, considering I know how databases work really well, and it wouldn't actually be a hard thing for someone to pull out of the database. But the important thing here was I did ask how many applications have been flagged, noted, tagged as having been asked incorrectly for applicants to provide medicals. How many were included in those applications? Now, they have said that 900 applicants had been affected. out of the 100,000, I suppose, there are in phase two, probably more than that actually. They said that the work to fix these were based on the individual health rather than the application itself. I then asked how many there had been fixed or how many were still to be fixed. There was 900 applicants, they said, in total, of which they said that they have all now been marked as being corrected. Now, those of you who are still sitting there looking at your application going, it's asking for a medical and your medical was done, it was valid when you made the application, will know that this is just not true. Neither is the 900 applicants in total. I think it's more likely to be 9,000 than 900, possibly more than that. But this is what we have received from them. Now, this issue itself, of course, we notified immigration of the issue back in, it was late April, early May, that this issue around medicals existed. And 7 months later, it still hasn't been fixed, and immigration seem to think it has. But talk to the immigration staff at the call centre, they will be able to tell you that it has not been fixed, and quite clearly it is still an issue. The first parent retirement category draw took place recently after years of delays. We do know that many of you have been sort of questioning whether whether it has taken place, where it's going. It's been very quiet. Not many ITAs have been seen. We have seen reports online of them being issued, so they are taking place. Remember though that there's 3 months between these draws taking place, and they could use that 3 month to send out the 500 ITAs. So they might sort of spread them out over time. So if you are lucky enough to have waited for so many years to actually get drawn in that first draw, then you may not get your ITA immediately. It may take a couple of months for them to actually process through it and get your one out to you, but we have seen them and they are going out. Finally, we have been asked to do a video covering sort of the post-decision options that you may have. So about complaints, reconsiderations, the Immigration Protection Tribunal, the IPT process, and other options you may have if you get declined a visa or you become unlawful. This is one of the areas we actually do a lot of work in, that handling problem files where things have not gone to plan, where Immigration New Zealand have made a mistake, or whether perhaps there's a humanitarian conditions involved need to be argued in court. We will do a video on this when we have a chance, possibly over the Christmas New Year break where things are a bit quieter. But I also want to be cautious, as when it comes to the IPT, it really is something where I strongly recommend you engage a lawyer, as that is what we are more legally trained to do and what we spend years learning how to do, and we spend sort of decades perfecting and practicing. And that's why we get good results, as what I do come from a litigation firm. While we will cover this in greater detail in another video, I did want to cover a quick few small points now about these sort of post-decision points. First thing is about timing. Now, these timing is extremely important. You will often only have a set time period that you can do this process in. If you don't, then you're going to be out of luck. Reconsiderations have to be raised within 2 weeks of the decision being received by yourself. And you can only do a reconsideration on a temporary entry visa, so work visas, student visas, visitor visas, things like that. You must also be on shore when you submit the reconsideration itself. So you cannot, if you're offshore and you apply for a visitor visa and you get declined, you cannot ask reconsideration because you are offshore. You must be on shore to submit the reconsideration. Once it's been submitted, then you can exit, but at the point you submit it, you must be on shore. For residence applications, or when someone becomes unlawful and they're on shore, then you have 42 days to submit to the IPT, being the district court level court, the immigration court that we deal with. Now, this is a pretty hard rule, and while the court can generally allow for a late application in most circumstances, we very rarely see the IPT allowing that. We've never had to apply late because we do that for our client in time. But when I have seen applications and I've read them online where people have applied late, generally the court will just say, no, you have 42 days and that is it, you've missed out. Now, of course, 42 days is 6 weeks. So basically the decision you get, the date that's on there, you have 6 weeks to go to the IPT if it comes down to residence or becoming unlawful. Or 6 weeks from the day that your visa runs out, you have that time to apply to the IPT for humanitarian considerations. But as I said, definitely get a legal assistance for that. Now, throughout this there's also the ability to raise a complaint if it can be shown that an error was made by immigration. It has to be an error which is blatant. It's objective. It's not sort of a point of view. It is quite clearly they have made an error in how they've done the process. Generally, you don't raise a complaint if you disagree with the decision, but if you can point out something that was misread or misdone, that's when a complaint can be raised. So, for an example, we once raised a complaint where a number, actually it was an income, had been misread. It stated an income, and the officer had misread the income, and based on that, had declined the visa because the applicant, according to the officer, was not eligible for the visa being applied for. We raised a complaint saying, well, look at the document again. You'll see that the figure that you've read or you've written down again was misread. Check the true figure. And very quickly, the decision was reversed and the visa was granted. So they did act very quickly and very fast on the complaint, and mistakes do happen. So I'm not going to hold it against immigration because that's what the process is there for. But this complaint process is there when there's an actual error that you can point out and say, hey, there's an error there, you haven't read this, or you've done that incorrectly. It's not about you feeling aggrieved that they haven't given you the decision that you wanted. There are some other options as well, which are less likely to get a result, and typically they take longer, they're a higher cost, or perhaps two or three of those things being higher cost, slower, longer, and more difficult. First is going to the Ombudsman. Now, the Ombudsman is there to review government activities, and they can get involved if it can be shown that Immigration New Zealand clearly made a mistake in their process. Now, it does require you to first file a complaint to Immigration New Zealand, give them a chance to resolve it themselves before going to the Ombudsman. If you go to the Ombudsman first, they will ask to see that complaint, and it's required under the legislation that the complaint is raised first with the immigration before you go to the Ombudsman. Now, the Ombudsman will take time to get involved. We have had some good results with the Ombudsman at times where there was a very clear issue, mistake, fault in the process by immigration. We raised a complaint, they refused to reverse it. And the Ombudsman came back and said, well, quite clearly there's an issue there, and immigration were required to fix their mistake. But it did take a long time of stress for our client, sadly, but that was just the only option open to them. Another option, but one that is already taken, is judicial review. Now, this is where a court is asked to review whether Immigration New Zealand correctly applied the law. Unlike the IPT, a judicial review will look fairly strictly at if the rules were followed and won't look at exercising any additional powers that a court may hold. So the judicial review are something we really look at as they're so limited in their scope as to what they will do. And then finally, there is the ministerial intervention. Now, this is where the Minister of Immigration, or in reality, the Associate Minister of Immigration, who actually does this task, are asked to intervene and to use their power to grant a visa or to make some sort of change. Now, typically this will work only in exceptional circumstances where the rules that apply to immigration don't quite fit the situation. We see a lot of people who go to the minister on the basis that they think it's unfair, or they think that it makes their life harder, and those ones will almost certainly be declined. The minister will say that they will not get involved. It's really those situations where something's taken place, or they're in a situation where the rules just don't seem to fit, because the rules only fit for the majority but not the exceptions on the edge, and that's where the intervention will often take place. And they are generally fairly reasonably fair in most circumstances for those who are on shore. If you're offshore, the minister generally won't get involved with an intervention. They'll generally just say no by default. Now, it does take time for them to respond. It can take some time. It can often be sort of 6 months to get a response. So don't see this as being the best chance. It really is one of sort of the last chances that you sort of go to if there is an issue. And that really is just it. A quick update on recent changes, a few things we've been thinking about. If we can assist you in any way with your legal work, please get in contact with us at the links down below in the description. Otherwise, please share, like this video, leave a review. And until next time, kia kaha and stay safe this December.